Good. Pardon me. Allergies, folks. Good morning, good morning, good morning. Excuse me. Welcome to a merry stupid o'clock to one and all. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. And this morning, we're going back to that horrible world known as the JRC. But before we do, folks, a few of the usual disclaimers. First off, you are going to see the link to these legal documents that we are going over this morning right there in the description box, alongside some of the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive on the subject, where we get the bulk of the material for this channel on this particular topic. We also have the templates, folks. Sign your name, click on your senator, takes less than 2 minutes. Let's end adversive therapies, improper restraints and seclusion in public schools. It costs lives every single year. We also have the self-explanatory, ever-present change.org Shut the Judge Rotenberg Center Down petition. Again, allergies. They're really bad. All right, folks. And when we are speaking about the JRC, trigger warning, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with disabilities being tortured and abused. If you have young children present, please use your headphones. And folks, not only is it 3:11 a.m., stupid o'clock in the morning, I am also running on 5 hours sleep. So if I stumble over any of my words this morning, my apologies in advance, alright? Okay, so we are going to where we left off yesterday in the Mr. and Mrs. Villa versus the JRC case. If you don't know what this case is about, please go back to yesterday's video so you can get the rundown, okay? All right, so count 1. Plaintiffs hereby reassert and incorporate the allegations of paragraphs 1 through 35. Devin Martinez in intentionally and physical contact with Miss Villa by striking her face with his fist. I'm sorry. Let me read that again. Devin Martinez intentionally made physical contact with Miss Villa by striking her face with his fist. This physical contact was harmful and offensive. Mr. Martinez punching Miss Villa caused her serious injury and emotional distress. Additionally, Mr. and Miss Villa have suffered economic losses, including medical expenses, travel expenses, and loss of income because of his actions. Under the doctrine of the respondent superior, the Judge Rotenberg Center is vicariously, jointly, and severely liable for any and all damages caused by its employee's actions within the scope of his employment. Thank you. At the time he struck Miss Villa, Mr. Martinez was employed by the Judge Rotenberg Center as a residential coordinator and was acting within the scope of his employment. Mr. Martinez is personally responsible and therefore jointly and severally liable for any and all damages he caused to his actions. Count 2. Civil battery, physical prompts, supported guides, and physical restraint procedures. Plaintiffs hereby reassert and incorporate the allegations of paragraphs 1 through 35. On an unknown number of occasions, various Judge Rotenberg Center employees intentionally made physical contact with Miss Villa to control her behavior as part of a physical prompt or supported guide. Judge Rotenberg Center employees responded to Miss Villa's attempts to physically resist or defend herself from this unwanted physical contact by restraining her. In restraining Miss Villa, Judge Rotenberg Center employees intentionally and physically made physical contact with her on numerous occasions. The physical prompts, supported guides, and restraint procedures were harmful and offensive. The cumulative effect of these repeated instances of harmful and offensive physical contact was that Miss Villa suffered physical injury and severe emotional distress. This in turn caused Mr. and Miss Villa to suffer economic losses, including medical expenses, travel expenses, and loss of income. Under the doctrine of respondent superior, the Judge Rotenberg Center is vicariously liable for any and all damages caused by its employees' actions within the scope of their employment. The employees in question were acting within the scope of their employment and carrying out physical prompts, supported guides, and physical restraint procedures. Great, my voice is still going in and out. Today's going to be fun. So the gist of all that, folks, is really one second, is that these employees were acting within the scope of their employment. So what her lawyers are saying is that, yeah, these aren't just some rogue agents. These aren't the we're bad eggs, as the Judge Rotenberg Center likes to call them. It was more than one employee, and it happened more than one occasion, giving the lie to what they try to sell to the rest of the public. Now, and on top of that, this is way after 2012, after the Andre McCollins trial. So, yeah, it's still going on, folks. Count 3, intentional or reckless infliction of emotional distress. Plaintiffs hereby reassert and incorporate the allegations of paragraphs 1 through 35. Various Judge Rotenberg Center employees intended to inflict emotional distress on Miss Villa through their conduct, or they knew or should have known this conduct would likely result in emotional distress. The conduct of the Judge Rotenberg Center's employees toward Miss Villa was extreme, outrageous, intolerable, and outside the bounds of decency within a civilized society. Damn, he doesn't pull no punches. I love it. The conduct caused Miss Villa severe emotional distress in the form of post-traumatic stress disorder, suicidality, self-injury, and increased levels of aggression. So much for stopping those behaviors, JRC. In turn, Mr. and Miss Villa have suffered economic losses, including medical expenses, travel expenses, and loss of income. Under the doctrine of respondent superior, again, sorry folks. The Judge Rotenberg Center is vicariously liable for any and all damages caused by its employees' actions within the scope of their employment. The employee in question were acting within the scope of their employment when they engaged in conduct that caused emotional distress. This also gives the lie of, but our programs help people and they're not really scared. Yeah, horseshit. Horseshit. Count 4. Negligent hiring and supervision. Plaintiffs hereby reassert and incorporate the allegations of paragraphs 1 through 35. At the time he struck Miss Villa to the face, Devon Martinez was employed by the Judge Rotenberg Center as a residential coordinator. The people responsible for other acts of physical, verbal, emotional abuse against Miss Villa were employees of the Judge Rotenberg Center at the time the incidents occurred. By having agreed to provide residential services to Miss Villa, the Judge Rotenberg Center owed her a duty of care that included hiring, training, and supervising employees in such a way as to ensure her safety and minimize the possibility of abuse. The Judge Rotenberg Center breached its duty to Miss Villa by failing to train employees to treat its residents in a humane and respectful way and discipline those who did otherwise. On the contrary, it created and perpetuated an institutional culture in which heavy-handed methods of behavioral control was tolerated, if not condoned. Thank you. As a direct and proximate result of the Judge Rotenberg Center's negligent hiring and supervision of Mr. Martinez and other employees who engaged in this conduct, Ms. Villas suffered serious physical injury and emotional distress. In turn, Mr. and Ms. Villa have suffered economic loss in the form of medical expenses, travel expenses, and lost income. Count 5. The plaintiffs hereby reassert and incorporate the allegations of paragraphs 1 through 35. By having agreed to provide residential services to Miss Villa, the Judge Rotenberg Center owed her a duty of care that included ensuring her safety while transporting her to and from school in its vehicles. The Judge Rotenberg Center had notice of Miss Villa's need for specialized transportation to and from school, as well as the range of dangerous behavior she was likely to engage in otherwise. The Judge Rotenberg Center breached its duty of care to Miss Villa by failing to provide her with alternate transportation and instead forcing her to take the regular school bus. And violating federal law, I might add. Reasonable accommodations is a thing, people. As a direct and proximate result of the Judge Rotenberg Center's negligence, Ms. Villa suffered severe physical injury and emotional distress. In turn, Mr. and Ms. Villa have suffered economic loss in the form of medical expenses. Count 6. Plaintiffs hereby reassert and incorporate the allegations, paragraphs 1 through 35. Both Section 504 of the Rehabilitation Act and Title III of the Americans with Disabilities Act prohibit discrimination on the basis of disability. They require covered entities to afford full and equal access to participation in and benefits of their services, facilities, privileges, advantages, and accommodations. As a receipt of federal financial assistance, the Judge Rotenberg Center is subject to Section 504 of the Rehabilitation Act. As a private residential educational and treatment program, the Judge Rotenberg Center is a place of the public accommodation within the meaning of Title III of the Americans with Disabilities Act. Ms. Villa is a qualified individual with disabilities that substantially limit several major life activities under both the Rehabilitation Act and the Americans with Disabilities Act. The Judge Rotenberg Center failed to make reasonable modification in policies, practices, and procedures necessary for Ms. Villa to participate in and benefits from its services, facilities, privileges, advantages, and accommodations. The Judge Rotenberg Center further violates Ms. Villa's rights under the laws by retaliating against her for engaging in the protected activity of making complaints about her treatment at its program and the effects it was having on her mental health. The Judge Rotenberg Center's discriminatory and retaliatory conduct caused Ms. Villa serious physical injury and emotional distress. This in turn caused Mr. and Ms. Villa to suffer economic losses, including medical expenses, travel expenses, and loss of income. Count 7. Unfair and deceptive acts or practices in violation of the Massachusetts Consumer Protection Act. Mass General Laws, Chapter 934. Plaintiffs hereby reassert and incorporate the allegations of paragraph 1 through 35. The Massachusetts Consumer Protection Act, Mass General Laws, Chapter 93A, prohibits unfair or deceptive acts and practices in the conduct of any trade or commerce. The Judge Rotenberg Center engaged in trade and commerce for the purposes of Chapter 93A by recruiting and then offering residential services to Ms. Villa in exchange for payment through the South Lake Tahoe Unified School District. The Judge Rotenberg Center engaged in unfair and deceptive acts and practices in the conduct of trade and commerce by making willful and knowing misrepresentations in the program description it provided to Miss Villa's school district and recruiting her for admission. The school district relied on the Judge Rotenberg Center's program description in deciding it was an appropriate placement. In turn, Mr. and Miss Villa relied on the school district's judgment in agreeing to the placement on their daughter's behalf. Remember, parents, this is why I say you can't just take people's word for it. You gotta do your own research. You have to. Miss Villa suffered serious physical injury and emotional distress while attending the Judge Rotenberg Center, which differed significantly in both nature and quality from how it represented itself. The Judge Rotenberg Center's unfair and deceptive practices therefore caused Mr. and Miss Villa to suffer economic losses, including medical expenses, travel expense, and loss of income. Plaintiffs, through their attorney, sent a demand letter to the Judge Rotenberg Center's attorney, informing it of their claim under Chapter 93A on August the 10th, 2018. The Judge Rotenberg Center, through its attorney, refused to make a reasonable offer of settlement in response to plaintiff's demand letter. Count 8, third-party beneficiary breach of contract. The plaintiffs hereby reassert and incorporate the allegations of paragraphs 1 through 35. The Judge Rotenberg Center and the Lake Tahoe Unified School District entered into the master contract, under which the Judge Rotenberg Center would provide residential and educational services to Ms. Villa during the 2017-2018 school year. Ms. Villa was an intended third-party beneficiary of the master contract. The Judge Rotenberg Center breached material terms of the master contract related to physical restraint procedures, physical punishment, verbal and emotional abuse, and employee conduct. Miss Villa, and by extension, Mr. and Miss Villa, suffered damages including pain, suffering, emotional distress, and economic losses because of the Judge Rotenberg Center's material breach of the master contract. Prayer for relief. Wherefore, plaintiffs pray that this honorable court enter judgment, awarding them double or treble damages in compensation for their past and future pain, suffering, emotional distress, and economic losses resulting from defendant's conduct, awarding them interest, cost of suit, and reasonable attorney fees, and awarding such further relief as shall be just and proper, as plaintiffs anticipate unknown additional damages will be incurred as a result of the actions of the defendants. Demand for jury trial. Plaintiffs request trial by jury on all claims and issues. So, folks, this is an ongoing court case right now. So let's talk about it a little bit. What has people like Judge Bernstein and the JRC themselves have continued to say? That what's happened in the past with Andre, with Antoine, that those were bad eggs, bad employees who have since then been fired, the training revamped, and that everything's hunky-dory now. But look at this, because these incidents from this court case happened just a few short years ago, 2 to 3 years ago, folks. It is still going on. And what you have are people who are not even remotely qualified to even work with your day-to-day patient, let alone people who are having mental health issues and people with developmental disabilities. They give inadequate training to people straight out of high school who have next to no experience working with people with disabilities or with mental health issues. They throw them through a boot camp of 3 weeks. And we are supposed to believe that this now makes them experts and that they can now do their do their job properly. But you can tell from this very lawsuit here that that is not the case. And anybody with any coherent common sense would be able to tell you that. They have inadequate training, they are completely inexperienced, and it looks like by and large, a good majority are completely immature and are unable to handle this type of position responsibly at all. See, Judge Bernstein from 2013 would have you believe that they have changed their hiring practices. They have not. He wants you to believe that they have tightened the rules so that now all the students are completely in a safe environment. They are not. They want you to believe that they only do this for the kids' own good, and it helps with their behavior. It does not, as is clearly the case with Miss Villa, Antoine, and Andre. It only exacerbated the issues that got them to the JRC in the first place and created some new ones that weren't there in the beginning. So, what are we to infer from this? The JRC are liars, folks. Judge Bernstein is a liar. All these parents are either brainwashed or are liars because the same type of behavior that landed Andre McCollins on that 4-point board with the employees laughing that the JRC tried to cover up, the same ones that ended with Antoine having to go to the hospital and Ms. Villa here, it's continuing on to this day. And to this day, the courts continue to protect them on an over 30-year-old 1988 finalized document due to that settlement. So, one after court case after court case after court case, and all the facts that have come out to this place, I have to wonder, what exactly is it going to take before people start taking this place seriously and get it closed down before it causes more harm? And on that note, folks, I'm going to go ahead and close out this morning. We don't get very many views on this channel, especially on this subject. The few that we do tend to get removed from time to time. So, folks, please don't forget to hit that like button, hit subscribe, don't forget to hit the comments. I do appreciate your time this morning, and as always, we here at Smelling Tea hope you have a good one. Bye-bye.